Okay, abusuya Kpandai constituency seat no ensema bahono enye ensem ketwa, and finally NPP for injunction say omreko PMO court application omreko PMO court no for seeking injunction and for stay of execution no abusuya court no wa Quǎšh yes application as you see no Kpandai seat ne de omo ankasa no omo akopie mu court ama court no abo omo application no ato agu enye asam keto akra na one of NDC legal team the lawyers no de ensem bi ababeto dwa yensem momre mom yenko na yenkonkotie ensma so unsubscribe subscribe, like and share ma afofro so ensa into me enkabi Ghana Politics Avenue. So and don't forget to click on the notification bell so there are any updates be able drop once able to me aka
the question will be whether or not the declaration by the High Court on the seat of Kpandai being vacant can empower the clerk.
The High Court has not declared any seat vacant.
Actually, that's true.
Because
it has not.
That power. They have said that there has to be a rerun.
But it has to.
That power is vested in the clerk. The clerk of Parliament. And Article 1125.
That's interesting because then a rerun, why would we rerun? Because
that's the outcome of the court case. But that mandate is not given. The mandate to declare a seat vacant is not given to the High Court judge. It's given to the clerk.
So, with my little learning here, if you look at that declaration by the High Court, it could be direct or emphatic this morning. Does that, if I want to go by what you're saying, does this mean that the clerk, after 7 days, can decide to say that I'm not declaring that seat vacant?
I mean, that's the scenario that Hamza was trying to paint you, that once there was an application for a stay, by which I also have a different opinion, that
before the application for stay, assuming the NPP does not even go.
There are two applications. There's appeal and there's an assay for execution. Stay of
no, you let me come in.
There are two things.
You see,
well,
Solomon,
you go ahead.
I have a different view as to whether or not notice of injunction or the mere fact that someone has applied for an injunction or stay constitutes a stay.
How about whether or not the directive from the court can amount to a declaration of the seats being vacant by the clerk?
So the court has given directions. The pronouncement as to whether or not a seat is vacant is the preserve of the clerk, and which the clerk has done.
So this is he says that the answer we must find is to whether when the High Court declares that, let it be a rerun.
And there's an appeal.
And there's an appeal.
Pending.
Can it amount to the clerk declaring the
Thank
seats?
you. That's what the issue is.
That's the issue.
The clerk has every right. Look, in the case of Haruna Idrisu, you see, in this country, it's always good that we have precedents. In the case involving Haruna Idrisu, Mahama Yarega, and Okujeto versus the Attorney General concerning the E-levy. You remember that case? When they sought to block the president from assenting to the E-levy because they had an issue in court, what did the president of the day say? He signed it. Because to him, notice the mere fact that you are going to court seeking an injunction did not amount to injunction. The mere, are you getting what I'm saying?
I'm with you.
So the mere fact that Nyindam and his people have gone to court seeking a stay does not amount to a stay being granted. Because as we speak, the only decision from the court is what we have with the High Court. And what does the High Court decision say? Say
rerun.
Absolutely.
Can that, since it is not a declaration that a seat is vacant by the High Court?
Yes.
And my learning is that it is the clerk, from you this morning, it is the clerk that has the power to declare that seat vacant.
Yes.
Can the directive from the High Court amount to that seat being declared vacant?
Absolutely. I'll give you the indication, but they do not have the power to say that it is vacant.
So they say, I know it, but I won't say it.
Absolutely. They know their level. Okay. Their level is to deal with the matter. They have dealt with the matter. It is for the clerk to declare the seat vacant, which the clerk has done.
So does the clerk have the power to say, I won't declare it? And then the Kpandai...
No, he has no power. He has no power. But of course he has no power. It's an order from the court.
Then it's an order, then?
Yes.
It's not in order.
That what?
then you're telling me now that the clerk has no choice.
Absolutely.
That's very emphatic.
Absolutely.
Okay, but Hamza, do you see the direction? Do you see what he says? Because it's the same constitution that empowers the clerk.
Yeah.
And it's the same constitution that allows a person to go through all of the judicial processes to get finality.
So the
do you
question
understand
is that Article 19, has that been exhausted?
But the mere fact that someone has also applied for a stay does not mean the person will be granted. Let's take this scenario.
It is not. But
let me just.
I don't know why we are doing this.
So that let's take this scenario.
Have to carry
if Ninam,
a level
between the state
we confuse
and
ourselves.
Ninam, if Ninam, the mere fact that application for a stay has been filed, and you allow Ninam to stay or be in parliament and continue to draw salaries from the state, in the event that the stay is not granted, how do we get that money from Yindam? Between the state and Yindam, who will have the capacity to reimburse the other? That's what you want to take into consideration. And that is why I believe that what the clerk has done is in order.
Okay. Hamza, but do you see where I'm coming with Kamal's issue that he's just raised?
Is that simple? Isaac, 4 years. It took 4 years. Just at the tail end of Parliament being dissolved.
I promise you that I think yours is right here. Hamza, let me get you. Let me hear from you. Kamal, I promise the issue is very clear.
First of all, there's a final judgment of the court. The fact that you have filed an appeal does not mean that it invalidates a final order from the High Court. That is not the position of the law. That is politics. Until such a time that an order comes from the Court of Appeal directing otherwise, as far as the High Court decision is concerned, there's a final conclusive judgment on the matter that is standing as far as the law is concerned.
So
and that is the decision of the
educators. What happened to appellate process? With all respect, if I go to a court of first trial,
no, but
a trial I'm just asking a simple question. No, you are a lawyer here.
But if you are patient for me to learn,
but in my simple,
it's a simple question.
It suggests that if the Court of Appeal questions the decisions of a lower court, their decision
I'm asking a simple question. Why do we have appellate process? You go to court A, and the court says, "This is my decision." The court now, the judicial process now gives you a window to appeal against it. And I'm asking simple questions.
But the CJ has
said it's final, and there's an appellate process that has been triggered. When the appellate process is not decided on, does it still mean that that decision holds?
But neither your stay of execution also has been granted,
exactly. So in the wisdom of the law,
there are two things.
In the wisdom of the law, they know that when a lower court gives a decision, it is binding. Until you take steps through an appellate process to set that aside.
Excellent. It is still binding.
It is still binding.
Yeah.
Excellent. If you are in court in the form of an appeal, the decision is still binding until such a time that the appellate court determines it. So they have given you tools to ensure that you protect your rights in the interim whilst the appellate decision process goes through. What are the tools? Injunction or stay of execution. But the courts themselves have told you that it does not mean that when you bring these tools before them, it will be granted.
Okay.
And so if you file a stay of execution and the High Court judge rejects your stay of execution, you wouldn't say that the vacancy is invalid because you are appealing, you are the Court of Appeal.
I can't help but come along with this logic.
Are you following the point?
Yeah, come along with
that is the law. And you see, my brother raises another interesting issue. And he makes the point that when it comes to an appellate process, like the application of for an injunction or stay, does not necessarily mean that it is stay. It is true. That is according to as recent as the Vincent Asafua matter. I think that the Supreme Court settled the matter and said that when it comes to constitutional bodies, the mere application for a stay of execution or an injunction does not constitute a grant of same, and for which reason one is expected to oblige, especially when it comes to constitutional bodies. And I'll just read it. This is Kulendi saying, JSC, in good conscience and in fidelity to our judicial oath, we cannot endorse a position that could potentially be exploited by deliberate and well-resourced strategy deployed by individuals or entities pursuing parochial private interests to obstruct, delay, and frustrate constitutional oversight and hold the public interest to ransom. And of course.
You have a higher authority.
And you see, yeah, Anna, but I need to draw a distinction where the confusion is.
Okay.
So this case is conclusive, it's tentative in a way. But even within the legal fraternity, when it comes to stay of executions under CI 19, it is statutory in nature. That one is specific. For example, the 7-day stay, automatic day stay. Then there's also under Article 2, Rule 27(2) or so, that says that the mere application of a stay would operate as a stay until the matter is heard. That is, the application stay is heard. It's also there. Are you getting the distinction, Solo? So now, there's that contention, whether this decision effectively overrides a statutory provision. A statutory provision that has been created and provided for in law. This decision relates to precedents of the same judicial, of the same Supreme Court. So we need that.
No, so you get it. We are on the same page.
It's a policy court.
So you see,
it's a policy court.
I have a question for all of you.
I
have a question for all of you. I have, but I have a question for you, so that we'll go to the OSP.
I am trying as much as
come on, are you people afraid of the Kpandai by rerun or something?
Let me just dispel this information that he seeks. We are not on the same page.
We are.
If there's anything, so I'm trying as much as possible to present the law as it is.
Okay.
And I'm challenging you people.
What do you?
Go through the legal process.
Let's go on the final round of the Kpandai. Let's go to OSP. Anyway. It means a lot to me because of a matter in court. My final question really is, what do you reckon is the reasoning behind the 7 days? Before you can
so that if
is it for such issues of stay of execution and appellate?
Exactly.
You see?
Exactly.
Let's go to the OSP.
Briefly. We also remember what Judicial had to go through. And the motion that was moved by the current minority leader in the case of Judicial that was intended and actually succeeded in preventing him from taking a decision as to who became Speaker of Parliament. It was an application before a court. That is the precedent you set. And so when we come and the same civil servants, or in this case the clerk, based on the precedents, are invoking the laws of the country to discharge their constitutional obligations, and you have a problem with it. I have given you basis where the confusion could be. And I've made it point that, Kamal, the antidote is not noise and recklessness and the threat to disrupt government.
The first time people are making noise in Parliament.
The antidote is to invoke the legal processes and challenge the decision of the clerk. But why are you afraid to challenge the decision of the clerk?
Your people. They have bastardized George and Co were all over on the floor.
They have destroyed the leader.
That one is that one.
And their leader has insulted the current chief.
We're all over in Parliament, saluting and dancing. That was wrong. Is that what they were supposed to do?
That was wrong.
Oh, that one was right.
Wrong.
Really?
There's almost
you saying that was
wrong.
Okay, let's talk about that.
I do not get a bite on the attempted propaganda.
You're late. Next time, come early.
My brother decided to do with utility price hikes, especially when we lived under very difficult circumstances.
You have mentioned it's unfortunate. Maybe another time when we are talking about
Yes, under very difficult conditions. And we are still living the effects of many of the bad choices that they exercised in the last 8 years. And like we continue to see, 11 months would not be sufficient to undo the damage these guys caused the Republic of Ghana in the last 8 years. And many of the effects can be seen in the power sector and petroleum for that matter. So he knows. If Ghanaians have every legitimate right to be concerned about hikes in utility tariffs. And unlike them,
when we have time, I promise we'll go back to it.
We would do whatever is necessary to ensure that we lessen that burden as we begin to get a handle on the economy and the effects of their bad policies in the last 8 years. Having said that too, on the Kpandai matter, listening to my brother, it is quite clear that he has been infected by the Addo disease.
What's that?
Erratic behavior that is not grounded in any form of rule or law, as far as the Kpandai matter is concerned. And that was what we saw 2 days ago in Parliament. You see, this is a country of laws. And whatever is done must be done in tandem with the law. And if you are a responsible citizen of the Republic of Ghana, and you believe that there's a discretion being exercised contrary to the rules of engagement or the laws of the Republic of Ghana, the most responsible thing to do is to invoke the same rules or laws to ensure that you protect your rights, not to be reckless. And out of your recklessness, undermining the very constitution you seek to demand your rights from. You don't do that. That is irresponsibility. And that point needs to be made. MFR, why do I say so? Look, the High Court is mandated under our laws, unlike the presidential petitions, to deal with issues of parliamentary disputes at the constituency level. That is the core mandate when it comes to elections of the High Court. A High Court judge has decided in accordance with the law that Kpandai needs to be rerun. Indeed, these were declaratory orders given by the High Court. The MP in question, some leading members of the NDC in Parliament, the front bench, immediately after the decision of the High Court, invited Speaker of Parliament to declare the Kpandai seat vacant. What did the Speaker say? The Speaker, they are chastising today, and the NDC. The Speaker took protection under CI 19, Rule 27, and says that in orders of this nature, there is an automatic 7-day stay, and resisted the invitation by the NDC majority to declare the seat vacant. That was the most responsible thing to do. He did that. And at the time he did that, you people did not chastise him as being NDC.
What does the law say that the Speaker should do after 7 days?
Wait. The law doesn't require the Speaker to actually even do anything. That's why I was interested in his declaration of his references to Article 112. MFR, read Article 112. That power of decision and declaration is vested in the Clerk of Parliament. Read it. The Speaker has no role to play in that particular Article 1125 he made reference to. Check Article 1125. And tell me where it is said that the Speaker, after a High Court has declared vacancy, the Speaker also has to proceed and declare vacancy. Tell me where. In Article 1125. And mind you, the clerk is performing a constitutional duty. This is not statutory. This is not, an act of Parliament. This is the 1992 Constitution of Ghana we are talking about. That places a responsibility on the Clerk of Parliament that anytime he gets such a communication, either from the Speaker or a court, that a seat has become vacant, he ought to oblige and write to inform the Electoral Commission of that vacancy. He receives a court order and he proceeds after 7 days on the basis of that court order to declare or to officially inform the Electoral Commission that a vacancy has occurred. So if you are a responsible political party, what do? And you know you have filed a stay of execution in relation to that particular judgment. MFA, what do? First of all,
it's actually the question everybody is asking.
Exactly. There are internal rules. Your own parliamentary rules affords you the opportunity to responsibly bring out the matter in the form of a motion to engage the conscience of the Speaker. Not demonstrations, not noise, not disruption.
What are you saying at all?
Only for the Speaker to walk in.
Oh, no.
You have forgotten all the internal laid down rules of Parliament and you jumped into the fray, threatening to disrupt government business, not NDC business. And these are some of the key things we must take interest in. And not Dompré on behalf of the NPP threatened the entirety of this nation. Because he said they were willing to disrupt government business. A serious crime.
He said they were not going to be part of it.
No, he was emphatic. He said they were willing to disrupt government business. disrupt the government, the business of the Republic of Ghana, you think that NPP's interest is much bigger than the interest of the Republic of Ghana, because we are not talking about an NDC interest. For a member of parliament to have the effrontery to dare the entirety of this country that he would disrupt government business is something we must all condemn. That is criminal in nature.
So if I understand, if all of this is happening in
Parliament...
Parliament...
He's not speaking to the issue.
Sorry?
You realize he's not speaking to the issue.
If all of this is happening in
Parliament... He has decided to dance around it.
What then should be happening to...
what issue? I'm speaking to the issue.
That allows the person to seek redress.
I am going to the stay of execution.
Okay.
Make no mistake. That is why CI-19 gives automatic stay of 7 days. It is clear that when it comes to certain forms of declaratory orders by a court, stay of execution cannot be attained.
Well, when it said certain forms, did it describe the form and shape these forms should take?
Yes. Many are of the view that the High Court declaration was not an enforcement or a directive to conduct elections. It was a declaration to the effect that the electoral rules were not followed, and so the elections were null and void. And so in that form of being declaratory, you actually cannot secure a stay of execution. It doesn't apply to it. That's one.
Wow. This is a school of thought of it.
That is a school of thought.
Okay.
Another school of thought says that if you look at the entirety of the declaratory orders, and it is such that it mandates another institution to do something, then you may be entitled to a stay of execution. And so those who agree with that school of thought are of the view that to the extent that the consequential effect of the nullity would be to the effect that the Electoral Commission ought to organize another election, then it is mandatory in nature and a stay could be possible.
When the High Court declares with the number of days, which is 30 days, does that not make it quite emphatic?
If it declares, well...
It says 30 days.
So that's the point. So then it comes under the mandatory school of thought, who are of the view that under such circumstances, you could secure a stay. But then, another interesting point that we need to appreciate is the fact that MFR, in the light of all that, your ability to subsequently get a stay empowers you to render otiose the letter written by Clerk of Parliament to Electoral Commission. Because the clerk is under a constitutional obligation to communicate to the Clerk of Parliament, to Electoral Commission, which he has done. If you subsequently get a stay of execution, it makes that letter irrelevant.
If you subsequently get the stay of execution after the declaration.
After the declaration of what?
The 7 days.
Yes.
After the clerk has written or notified the EC that the seat is vacant.
In fact, after the stay, if he gets the stay of execution, the Electoral Commission will be prevented by that stay from actually proceeding to declare a date for the election.
What then happens to the...
And if they had already declared a date for the election, then it becomes difficult for them to go by that date, because by then there would have been a direct stay order. What is not true?
You land.
What is not true? No, what is not true?
What you are saying, but
if today the Electoral Commission... No, you don't understand it. So
don't worry.
The Electoral Commission yesterday didn't they set a date for the election, 30th. So if tomorrow we have a stay from the court, will the Electoral Commission proceed with the 30th date? MFA, will they be able to... Will they violate the court order and proceed to organize elections on the 30th?
By this time, what will the declaration of the vacant seat, what would then happen to that declaration?
It means that it is stayed. It does not mean that the declaration is rendered void. It only means that the implementation of that declaration is put on hold.
Or the implication of that direction?
No, the implementation of the decision, the earlier decision, because the directive is that, look, there's a nullity. So if there's a stay on the High Court's decision, it simply means that don't implement the order yet. Wait until a final determination of the matter. That is what a stay means. Perfect. MFI, are you following? That is what a stay means. So if they say stay the implementation, the Electoral Commission would have no option than to oblige and respond by staying.
But by this time, where it will have an impact in the implementation of that action of the vacant seat being declared in Parliament, what then happens to that particular seat, the Member of Parliament and all? What then happens?
Because there is a stay. That is why I told you that the letter then becomes ineffective. The letter coming from the Clerk of Parliament to the Electoral Commission.
Agreed.
Because to the extent that the stay, that means the status quo would be forced to remain.
I want to take you back. Because something must have triggered that declaration of the vacant seat. So if that stay of execution, which would have then implemented the effect of that declaration, is stayed, we'll take 2 steps back. What then happens? The Member of Parliament...
taking 2 steps back. They are just telling you that things should stay as they are.
Okay, and then the seats will be declared vacant.
The vacant MP be given an opportunity to sit. And in that case...
To sit?
Yes.
Yeah, he can go back to Parliament.
This is what I want
yes,
to know.
he can.
Yeah.
He can. He can. That is why. Oh, if you were... That is why he can.
Okay.
If there is a stay. And that's why I'm telling you that the letter of the clerk becomes irrelevant because it is the letter that has declared the vacancy.
Okay. It's
and
really
communicated...
I need a clarity because the letter can be irrelevant. Does not mean that that seat is still not vacant.
Oh, no, it will be if the letter... Because the basis of now... The basis of the declaration of the vacancy now is that letter.
Okay.
And if the letter... Please, can I finish? Okay, you finish. Please.
So,
you are done with the submission. We are getting to solutions.
Why? Yeah. I'm receiving text messages that suggest that they want to learn.
Yes.
They want to just follow.
Yes. So let me land on this issue. My point has always been quite straightforward. I indicated that to the extent that there was a stay in execution, an application for stay of the execution of that particular judgment, the Clerk of Parliament would have exercised 2 options. Either to protect himself with the stay application or proceed to honor the constitutional obligation under Article 1125. He has elected to do the latter.
The latter.
By doing so. If he had done so, if he had refrained from doing so and proceeded that, look, this is the course I want to go, I'm sure that he would have still been protected. And I think that is the misinterpretation they got from my analysis. I do not have any problem. In any case, they were supposed to sit on the stay application yesterday, the same High Court. I am not aware as to whether indeed they did or not.
Yeah, then they did, but then the outcome will be made known on 18th. On
18th. So I am not aware as to whether they did or not.
Okay.
But from where I sit, it is practically impossible in accordance with the law for any application of a stay to succeed in this matter. And you can quote me anywhere. Yes.
What did you say, sir?
And mind you, before the clerk takes such a decision, Parliament has its own legality.
Okay.
They would have engaged. The possibility of a stay, I do not see that happen. I do not.
I mean, they say that good lawyers are those who are able to find the law.
I do not.
Right?
I do not.
If you find a good lawyer and it happens, it means that
the basis of your stay is going to be that you have filed an appeal. And so therefore.
I mean, it's not strange.
The standard for stay of execution is higher than just the mere filing.
Why are you worried for them? Maybe they're very certain.
And you see, MFA, let me land. These are the people, under a minute, these are people who on one breath are chastising our judicial system.
Absolutely.
And saying that is the reason why they are not willing to go to court to enforce their rights, because if they go, they will lose. So they opted to demonstrate in Parliament. On another breath, that same group of people are those inviting us to respect a mere application for a stay of execution of a court, and that we are undermining the court.
Well, I mean,
or the Clerk of Parliament.
How is that your worry?
What kind of contradiction?
We want to stay in the learning that way.
When the law favors them.
Come out. Solomon, I'm going to come.
Okay, abusia we ne ensema ekoso ewo political highway so eye NDC lawyer baako ena yete ne nka etese ode Kpandai seat no ehonsem ede tudwa ede maaye no unsubscribe ya subscribe like na share ma afofron so ensa into me enka bi aha Ghana Politics Avenue so medamase